that protect Australians against different forms of hatred are actually really diverse. So there's very little consistency across the whole country. Some of those laws are civil laws, some of those laws are criminal laws. And that's actually a really important difference, because when we're talking about civil laws, for example, we're talking about a situation where someone can make a complaint to a human rights agency, but that won't actually mean that the person is prosecuted by the police. Civil laws have quite a different process in this area. So if someone does make a complaint against a form of hatred, say hate speech, for example, then it would go to a human rights agency. They would look at that complaint, and the person that the complaint has been made against might be asked to come in for a conciliation hearing, which is where they sit down with the complainant and they talk through the issues. The outcome of that might be, for example, an apology. But it's very different from the criminal law, where somebody makes a complaint to the police, the person is prosecuted, they go to court, and there, in a criminal case, the outcome could be, for example, a fine, or it might be, being imprisoned. So these are two quite different areas of law. And so what that means for the problem of hatred is that different forms of hatred might be governed by a civil law, or they might be governed by a criminal law. And that varies considerably between the states as well. So one of the things that's important to understand about Australia is that Australia is a federation. So what that means is it's made up of different states and territories, and they all have different laws. And so if you're talking about the laws that govern hatred, there really is only a very small body of laws that govern the whole country. And the prime example of that is the laws that govern racial hatred under federal legislation. These are civil laws, they're not criminal laws, but they do apply to the whole country. So the racial hatred laws that govern everybody in Australia, basically what they do is they outlaw public behaviour that offends, insults, humiliates or intimidates somebody on the basis of their race or their ethnicity. So that's the only category that they apply to. They don't apply to religion or sexual orientation, etc. But this idea that the behaviour or the public conduct has to offend or insult or humiliate or intimidate somebody, it also has to be a form of behaviour that causes profound and serious effects. It's not going to be enough if someone is offended, but they've taken offence at what might be called a mere slight. That won't be sufficient. There has to be some form of, as I say, profound or serious effects. So obviously that limits the application of these hatred laws because they only apply to race and ethnicity, and they also set a fairly high threshold of harm. So there are a whole bunch of other civil laws that operate in different states and territories. Most states and territories do outlaw particular forms of vilification or incitement under the civil law. So the civil laws that outlaw different kinds of hatred and at the state and territory level, they all set really quite different tests for how the courts are going to determine whether or not the law has been breached. So for example, in Victoria, public behaviour that incites hatred, serious contempt, severe ridicule or revulsion is actually the test that's set under the law. You can see that that's a really high standard, and it's actually higher than the federal laws. And again, in Victoria, those laws only apply to race or religion. So what you have there is you have a combination of things. You have laws that are quite restricted by only applying to certain categories, and you have a very high threshold of harm that has to be met before the law will be breached. And then if you look at New South Wales, to take another example, there the laws are quite different again. New South Wales has quite particular criminal laws to address different forms of incitement or vilification. And these laws were only brought into place in 2018. And one of the reasons that they were enacted was because it was recognised that there were problems with the existing laws that operated at that time in New South Wales and that are very similar to the laws in other parts of Australia. So now in New South Wales, it will be a crime for somebody to threaten or incite violence against others on the grounds of race, religion, sexual orientation, gender identity, intersex status, or having HIV or AIDS. So this is actually a criminal offence, and someone can go to prison for this behaviour if it's in public. But again, you can see that that's quite hard to prove. You have to actually have evidence that the accused person threatened or incited violence against others. So it's interesting that since these laws in New South Wales were introduced in 2018, there has never actually been a successful prosecution. And this is a common problem that we see in this area across Australia when we're talking about the criminal laws that govern different forms of hatred.